and let's keep our mic muted and our cameras off. We are going to allow questions at the end of the presentation, and I am not stopping anyone to post on the chat box any comments while the presentation is running or any questions. We will address those together with your live questions at the end of the presentation. Thank you very much. Let's enjoy the discussion. Thank you. Hand over to you, Magauta.
Thank you, Oma, and welcome to everybody to this webinar. I'm just going to do a short introduction, which includes introducing our main speaker for today. After that, I will hand over to Mr. Janus. I just need to point out we are going to post a disclaimer. As an Ombud office, we are sharing this information for information discussion purposes. It should not be constituted as legal advice because, as you know, each case that we deal with is dealt with based on its merits, on circumstances, on fairness, and so on. So this is just to give you a guidelines and to open for discussion. But of course, if you have to seek legal advice, please do so. And then I thought it is important that I should share a short description of our mandate. Besides mediating disputes, we are required to give guidance to the industry in terms of how they should interact with consumers, how they should deal with consumer disputes. And of course, we need to educate consumers about their rights and obligations, as well as access to redress. So what we are doing today is, of course, in compliance with our mandate to ensure that our participants, potential participants, those that haven't joined up yet, which is a compliance requirement, and of course our consumers and other stakeholders have a very established understanding of the Consumer Protection Act so that they can improve how they transact with consumers and also their internal policies that deal with these issues. Today, we are very happy to have Janus, who is a very seasoned consumer protection expert, legal expert, who is going to address the issue for us. Janus holds degrees in both chemical engineering from the University of Pretoria and law from UNISA, and is a registered attorney, patent attorney, and a professional engineer. He is a partner of Han & Han law firm. Janus is a custodian member of the South African Association of Food Science and Technology, as well as serving on the FSI for some of his clients. He has assisted many leading listed companies, as well as the Consumer Goods Council of South Africa, which is the industry body that established the CGSO, and SAFOST with their various foodstuffs, cosmetics, and Disinfectant Act and regulations, Medicines and Related Substances Act and regulations, and the Consumer Protection Act submissions to various government departments and parliament, as well as the implementation of the CPA in their businesses. Most recently, Janus acted on behalf of the CGSO and was successful in having the High Court confirm the obligation of all FMCG participants to enroll with the CGSO and pay their annual fees. So Janus is quite an activist in the area of consumer protection, and we are glad to have him with us. Before I hand over to Janus, I just want to give you a little bit of the types of complaints that we've dealt with in the last quarter, and why we chose to focus on warranties. For the first quarter of 2022, which is from January to March, we received 2,743 complaints and we closed 2,636. And we were able to assist in the refunds being paid back to consumers amounting to 2.4 million. What is of interest, of course, is the type of complaints that we are receiving. You will see that a majority of the complaints there relate to goods or services not being delivered on time or within reasonable time as per agreement. And a lot of those relate to online transactions. And then we have the second one, which is 15%, goods being defective within 6 months. And that is the topic that we are going to deal with today, because as you know, consumers have an automatic warranty of 6 months, where if the goods are defective, they are entitled to a repair, a refund, or a replacement. And this 6 months runs concurrently with the manufacturer's warranty. So you will see at the bottom there, we do have complaints where I think it's about 5% of them where goods are defective after 6 months, which means that is where the manufacturer's warranty kicks in. So you can see that we do receive quite a lot of complaints relating to goods being defective, where the automatic warranty of the CPA has to kick in, or that of the manufacturer, depending on when that happened. So that is why today we want to address, although we did say the topic is, does a stain on a mattress void a warranty? What Janus is going to do is to take you through all the provisions in the CPA relating to warranties. Thank you, Janus. You can take over, and thank you for agreeing to do this presentation for us. Let's see.
Thank you very much, Martha.
Let me
it's a pleasure to be.
Did I stop sharing?
Not yet.
No, I think it's still showing. Let me see if it will allow me to share overview. Can you see my presentation?
Yes.
Can.
There we go. So, good morning, everybody. It's a pleasure to be with you today. The topic we're discussing today really is the right of return, with the example being that of a mattress and potentially a stained mattress. You know, this is a very interesting topic. The right of return can be very contentious. There isn't a simple formula to determine exactly when a consumer has a right to return something. It's various shades of gray often. You know, when is something not fit for purpose to the extent that it should be able to be returned? And especially this applies to subject matter such as motor vehicles, where, you know, a scratch in the paint doesn't necessarily render the vehicle of no use. But let's talk today in terms of a mattress, and one which has been bought by a consumer, and the consumer now wants to return it because they have a complaint about the mattress. So first of all, we must remember that consumers are more and more aware of this each day, that they know their rights. As a consumer, they think they understand them, and of course they want to enforce them. And I think this slide really brings that message across. So again, I will reiterate the disclaimer that was already to some extent read by Magauta, and that is that this presentation is not legal advice. Today we are presenting a general discussion about consumer rights and the consumer's right to return goods purchased from a business. So it does not apply in private transactions if you bought something on Facebook Marketplace or something like that. And then the CGSO team consider the fact of each and every case and apply the equitable principles of the Consumer Protection Act in making their recommendations. So hard and fast rules are very difficult to have because the Consumer Protection Act does require fairness to be a consideration. So let's go into it. So what are the rights of return of something like a mattress? You know, this presentation, as I say, specifically excludes any private sales. It only applies when a business sells something to a consumer. And there you see a mattress with a lovely stain on it. And now you're in the business and the consumer says, I'm not happy with the mattress, I want to return it. But let's first understand the legal basis of why a consumer would have a right under certain circumstances to return a product. So the first right that the Consumer Protection Act gives is a right to return goods for a refund within 10 days. And that is, the product doesn't have to be defective in any way, but the consumer did not have an opportunity to examine the product before at delivery. If the goods are not the same as those in a brochure or the sample that was shown in the shop. Very important one, goods are not suitable for the purpose for which they were sold. So the mattress is not defective, but it's not suitable for the purpose. So the consumer came into the mattress shop and says, I'm 2.1 meters tall and I need a mattress that's going to work for me. And you send them a standard length mattress, which obviously is too short. So although there's nothing wrong with the mattress, it's not suitable for the purpose for which they specifically stated they needed it. Or, for example, an extra weight mattress. You know, a mattress will have a rating, maybe it's for up to 120 kilograms, and the consumer says, well, I'm 150, I need a mattress that will work for me. There are no exceptions at this stage. Only medicine is exempted. So you can't say, well, I don't take a mattress back because what am I going to do with a mattress once you've used it? The Consumer Protection Act gives the consumer to return the product within 10 days. The one big exception is if the consumer has in any way altered the product, disassembled it, etc., then there's no right to return. So they've now gone and stitched a cover to it or removed the legs or done something to it. Then they lose this right to return. But please bear in mind, this right to return is not a right of return because there's something wrong with the mattress, as in it's defective. It's not what they were told they were going to get, not what they ordered. Then there's another right of return, and Magauta mentioned this, about delivering goods on time. So the Consumer Protection Act provides for timeous and accurate delivery of goods. Goods must be delivered at the agreed time and place, and only agreed delivery charges can be charged. And the risk of delivery, the risk in the goods only passes on delivery. Agreements to the contrary are dangerous, as the Consumer Protection Act frowns upon unjust and unreasonable terms, and they'll be presumed unfair. So let's take an example. A truck is transporting mattresses, and your terms and conditions say the risk in the mattress passes to the consumer as soon as it leaves our warehouse on the truck. Bearing in mind, it's not the consumer's truck, it's your truck. The truck that gets into an accident or it rains into the truck. You can't say to the consumer, well, the minute the truck left our warehouse, it became your problem. That would be presumed to be unfair, and the consumer would have rights in terms of the Consumer Protection Act. And then, of course, we spoke about incorrect delivery, but there's another angle to incorrect delivery, and that is if the right goods are delivered to the wrong person, or the right person gets the incorrect amount of goods, then as long as the consumer has notified the company, listen, why did you deliver this to me? This is not what I ordered. Then if the company doesn't come to pick it up, the consumer can keep it. It actually becomes forfeit goods and becomes the free property of the consumer to whom it's incorrectly delivered. I haven't seen many cases like this. In the early days of the Consumer Protection Act, I dealt with a matter where a refrigerator was delivered to the incorrect address because two suburbs had the same street name. And the delivery van simply went to a number in a street without realizing it's a wrong suburb, dropped off the refrigerator with a member of staff of the household and left. And after 20 days, that refrigerator became the property of where it was delivered, even though those people had never ordered a refrigerator and actually initially didn't even know where it came from. So it's very important that proof of delivery, logistics control, etc., are all done very tightly so you know what's going on. Now, Section 22 of the Consumer Protection Act requires that all information to consumers must be given in plain language, and plain language implies it must be understandable to an ordinary consumer of the class of persons for whom the notice is intended, with average literacy skills and minimal experience as a consumer of the relevant goods and services. Now, these last few words are really critical. With average literacy skills, and secondly, minimal experience as a consumer of the relevant goods or services. It is not a defense to say to the consumer, but everybody who buys a mattress knows. You must presume the consumer knows nothing. It's the first mattress they are buying, and if you didn't tell them, they don't know. And this also applies to marketing campaigns, labeling, promotions, competitions, etc. So, in terms of the consumer's rights, plain language is required on all advertising, documentation. If you're giving somebody a warranty document, that should be in plain language. It must be understood by the ordinary person. The layout, the use of vocabulary, very importantly, the use of images will all be considered to determine whether or not you are giving information in plain and understandable language. And this is especially important for things like storage instructions, cleaning instructions, health warnings. So if we're thinking of a stained mattress, and I'm going to get to that now, you may be wondering, what is he on about? There needs to be warnings on how a mattress must be treated so that it doesn't get stained by the consumer. What cleaning materials, that it mustn't be made wet, etc., etc. And this must be not in some one-point font at the back of something. This would need to be front and center, clear, easy to understand, because it's a key issue around the product. So Section 24 of the Consumer Protection Act says that any trade description on or in relation to goods, even in brochures, etc., must not be misleading. So if your brochure says stain-resistant mattress, but in fact, when I drop my cup of tea on it and I wipe it off, it leaves that yellow stain you saw. It's not stain resistant, and therefore that trade description is misleading. And retailers may not sell goods which it knows or reasonably could determine, but the lowest hurdle to jump over is has reason to suspect that it contains a trade description likely to mislead the consumer as to any matter implied or expressed in that trade description. Now, this is important because this is the duty of the retailer. So a retailer cannot turn around and say, no, this is the problem of the manufacturer or the importer of the mattress. We just sell it. Because it is the duty of the retailer not to sell those goods if they had a reason to suspect that the trade description is misleading. For example, never stain or won't stain or stain resistant or words to that effect. And this brings us to the whole issue of fair and responsible marketing. So marketing may not be false, misleading, or deceptive, whether directly or indirectly, including exaggeration, innuendo, and ambiguity. And if as a supplier you become aware that a consumer believes something which is not the fact, it becomes your duty to correct their misapprehension. Their misunderstanding becomes your responsibility if they express that misunderstanding to you. So you are telling them it's an easy to clean mattress, and they say to you, oh, this is wonderful. The children can jump up and down on it and it will never get dirty. You would need to say to them, no, that's not what this is. If you don't say that, then in fact you have misled them through your silence. One may not falsely claim goods are available when they are not, and that goods can be delivered within a certain period, knowing it cannot. This comes back to that other issue Magauta was speaking about. You can't claim an advantage of price you don't have. But here's an important one. One cannot claim product quality, characteristics, properties, uses, benefits, or advantages that a product does not have. So if you have a mattress and you're claiming it's orthopedic or it has some other special pockets, I've seen mattresses that say they're made of NASA space-age materials. Well, if it's true, it's true, but you better make sure it's true. Don't make these claims if it's not. Because if your claims are false, the National Consumer Tribunal could in fact fine you as high as 10% of your turnover. Now, in the context of mattresses, we need to understand what this means. So the Federal Trade Commission in the USA charged 2 mattress companies who made unsupported claims that their mattresses were chemical-free and odorless. They, for example, also challenged another company's claim that its mattresses were made from 100% natural materials, and another company's claim that its mattresses were certified by organic mattress organizations. So there are a lot of claims in the world around mattresses, and for example, in America, they have gone and taken on certain mattress manufacturers around false claims. This brings us to the whole issue of fair and just. And you know, the CGSO is substantially about being fair and just. A supplier must not offer to supply, or enter into an agreement to supply any goods or services at a price that is unfair, unreasonable, or unjust. Let's forget that for now. But let's not forget on terms that are unfair, unreasonable, or unjust. So you cannot enter into an agreement which is so one-sided that a consumer is disadvantaged because you now, for example, say, you carry the risk on this mattress the minute it leaves our warehouse, or as soon as it leaves the factory, or once your order is placed, or whatever you can dream up. So before the Consumer Protection Act existed, you had a freedom of contract, and in fact, to a large extent, you could enter into agreements like that. But this has now been done away with. All agreements must be fair and just, and you cannot deprive a consumer of the rights they would otherwise have. So this brings us to section 55, safe good quality goods section. This is the section often referred to as the warranty section, and it says that goods must be, number 1, reasonably suitable for the purpose for which they are generally intended. Now, reasonably suitable doesn't mean 100% suitable. And this came up a lot in cases relating to return of motor vehicles. Let's just discuss that for a second. So a person buys a motor vehicle and there's a scratch on the mirror. And they notify the dealer. They say, look, there's a scratch on my mirror. I want you to take this car back. And the dealer says, no, this is not a substantial defect with the vehicle. It's still perfectly suitable for the purpose for which it's intended. It's intended to drive you and take you from point A to point B. We're sorry about the scratch, but we will fix it. So reasonably suitable doesn't mean the goods are 100% perfect. They must be of good quality, in good working order, and free of defects. So B says something else from A. It's suitable for the purpose. It's a mattress. You can lie on it. You can sleep on it. That's the purpose of the mattress. But now there's this little stain in the corner. Now what? Well, is it a minor defect? Is it a material defect? And if it's just a minor defect, in general, a supplier gets an opportunity to resolve a minor defect. So can the stain be removed, and where is it on the mattress? You know, if you have a mattress which says, never need to turn it over. It's one of these mattresses you don't need to turn over. And the stain is on the bottom. Then clearly that is not the type of defect that would entitle a return and replacement of the mattress. The supplier would get a chance to clean it. But if it's a stain on top of the mattress where you're going to sleep, and it's a blood stain or urine stain, that's a whole different story, because somebody may say, well, this is completely unacceptable. I can't sleep on this. So the fact that there's a stain doesn't automatically result in one or other situation. One has to look at it very carefully and say, Is it a minor defect? Is it a major defect? Can a stain be removed? Where is it on the mattress? Then only you can decide, is it of good quality, in good order, and free of defects? Now, I'm considering the case here where the mattress is delivered to the consumer already with the stain. I'll deal in a minute with the situation where the mattress was delivered without a stain and now the consumer wants to return it for a different reason, but there's a stain on it. Then it says that a product must be usable and durable for a reasonable period. Well, this doesn't really apply to the stain, and it must be compliant with applicable laws and standards. So when we consider reasonably suitable, the consumer can only judge what something is reasonably suitable for by looking at the marketing, looking at the packaging, discussion with sales staff. I remember years ago watching on TV, there used to be an ad where there's a woman sleeping on a mattress, there's a tiger walking next to her and she doesn't wake up. So, you know, those types of things which make good advertising, and somebody probably got an award for the ad, but what is the expectation it creates of what is this mattress reasonably suitable for? So, as I said again, when you're talking about fit for purpose, be careful of puffing the benefits of a product because you could be held to some extent to the claims you make about the product. And now we come to important issues of something like a mattress. If there's any size and weight limitation for a user, so maybe most mattresses are designed for people up to 1.8 meters tall and who weigh 100 kilograms. And now you have a customer and he's 2 meters tall and weighs 200 kilograms. What do you sell him? If you simply go and sell them the normal mattress when he's standing in front of you and you can see that he's 1.9 or 2 meters tall and he weighs 200 kilograms, then you are in fact warranting that it's fit for the purpose for which he's buying it, which is to sleep on it. And if he buys it and he takes it home and within a couple of days it develops a dent and his feet stick over the end, he returns it at your risk and he can get a refund or in exchange for a correct one. And then there's the issue of durability. Must be instructions on how to use, instructions on what not to do. For example, how not to clean it, don't use water, or don't use strong chemicals, etc. And issues like wetting the bed, etc., also affect durability. So all these warranties of good quality goods lead to the implied warranty of quality, the so-called 6-month money-back warranty. So any goods that are sold within a business carry a minimum of a 6-month money-back warranty. If you have a 10-year warranty, then for the first 6 months, the Consumer Protection Act will apply, and the rest of the 9.5 years, you can have whatever terms you want in your warranty. You can include co-payments, you can include all sorts of things in your remaining warranty. But for the first 6 months, the minimum that you can give a consumer is the CPA warranty. And before I read those 3 lines, this little block in the yellow block, this is actually from the returns brochure of the National Consumer Commission. And to be absolutely clear, they say that a good refund policy is as following. Please choose carefully. We do not normally give refunds if you simply change your mind or make the wrong decision. So consumers have no right to return anything simply because they don't like it anymore. When they get home, they don't like the color, it doesn't suit them. The consumer who chooses a product, it's theirs. You don't have to take it back unless there's something wrong. The second part of it, it says you can choose between a refund, exchange, or your money back, where goods are faulty, wrongly described, different from the sample shown to you, or do not perform as they are intended. But you need to obviously have a proof of purchase. So the producer, importer, distributor, and the retailer each warrant the goods. But of course, a consumer is dealing directly with the retailer, and in most cases, the retailer would have to turn to their supplier to indemnify them against any claim by a consumer. And within 6 months after delivery, a consumer can return the goods to their supplier, which would be the retailer. But in some cases, they may be able to return the product directly to the factory without penalty and at the supplier's risk and expense. So if a product is defective, you cannot tell the consumer that they must pay to take it back to you. If it's truly defective, you at your expense have to go pick it up or refund them for the delivery costs. And then when they are returning it to you, they can either return it to you for a refund or for a replacement. Or, of course, they can opt to accept a repair. But if the second situation arises within 3 months, then there are no more options. The law says you have to refund. So I dealt with a situation on a carpet, not on a mattress, where there was a stain. Company came, did a steam wash, removed the stain, but the problem was deeper. The problem was something inside the floor. And within a fairly short time, the stain reoccurred, the exact same stain, in which case they no longer have the option to say, we'll come and clean it again. Because this happened within 3 months, a refund has to be paid. So, critical to the whole issue of the consumer's right to return, or what are the warnings and instructions you're giving them? So first of all your labeling has to carry correct information in plain and understandable language. So you must have warnings of hazards and clear instructions. If there are any allergens, you need to warn them. How to store the product. If it should be kept out of direct sunlight, otherwise it will fade in one corner or whatever, you need to say that, keep out of direct sunlight. If there are specific cleaning instructions, or if you should not clean it, it must clearly say, this is how you clean it, or this is how you don't clean it. If certain chemicals mustn't be used, it needs to say it. What about staining and stain removal? Maybe that should be in the warnings and the instructions as well. If it's a situation where you're giving somebody a mattress on a try for 30 days, and if you don't like it, return it, there should be a warning. Use a protective cover to prevent damage on it. You can't tell them you can't return it now because now it's got a stain. If you never warned them to begin with, that they should have some sort of cover to protect it from a stain. Alteration of goods becomes very contentious because the Consumer Protection Act says that you have the right to return goods if they are defective, except to the extent that those goods have been altered contrary to the instructions. So if your instructions are very clear about how to use a product, they now come along and spray it with some substance. They go to the supermarket, they buy what they believe is a stain protector. But the stain protector is actually intended for a different type of material. So they now go and spray the mattress with this stain protector. And in fact, it causes staining, or it creates a smell, or they spray it with some sort of perfume substance that makes it smell better. Then they are altering the goods, and they would no longer be entitled to return the product. Maybe they remove the feet, or they alter it in some other way. They decide to stitch something to it, cover it with something permanent, not just a pullover sheet, but something permanent. So in those instances, they cannot return the product, even if it's defective, because they have altered it. I mean, you may, of course, choose to meet them halfway as a gesture of goodwill, but the Consumer Protection Act would be on your side if they altered it contrary to the instructions. So amongst the exceptions of the right to return are a consumer gets informed that particular goods were in a specific condition. There's a sale, shop-soiled goods are on sale. There's a little stain in the corner or a slight yellowing, and there's a sign up and it says, shop-soiled mattress for sale, has stain in bottom right-hand corner. Eyes it. Corner, because they were told about the defect before they bought it, and they knowingly acted in a manner consistent with accepting the goods. More importantly, it was written on the notice, and when they bought it, ideally they signed a thing that says, we are aware that this is a shop-sold product. So when somebody buys a shop-sold product, which is clearly marked as such, then they would again not have the right to return it for that reason only. But of course, if the wooden frame broke, then the fact that they bought a shop-sold product with a stain on it wouldn't deprive them of their right to return the product because the frame broke, but it would certainly deprive them of the right to return the product because of the defect which they were aware of, but chose to buy it anyway. So a person who offers to agree to supply any goods that have been reconditioned, rebuilt, or remade must apply a conspicuous notice to those goods stating that they have been reconditioned, rebuilt, or remade. Now, what are we talking about here? In the context of mattresses, somebody might return a mattress and then you clean it, try to make it like new, and you now sell it as shop-soiled goods. But you need to notify the consumer that this is in fact what it is. And these goods are not considered to be used goods, interestingly enough. And this, of course, could irritate consumers because the Consumer Protection Act defined used goods, that any goods previously supplied to a consumer but returned to the supplier in terms of a right of return are not considered used goods. So these are not used goods. They're still new, but they have been reconditioned or whatever the case might be. And you need to notify the consumer that something about their condition is not as they would expect it. But what about consumer damage? So consumer buys the mattress, there's nothing wrong with it. They get it home, they rip the plastic off, and now they're using it at home. So a product would be eligible to be returned for a refund, but it's now been altered. Well, if it's been altered in any way, maybe they've decided to bolt on a wooden headboard or do some structural change to the bed, cannot be returned. The damage is a result of not following clear instructions provided with the product, cannot be returned. A more interesting one is product abuse. If it's a product that is sold for domestic use, and it is clearly indicated this is for domestic use, and then somebody goes and puts it in a guest house or in a hotel, they would not be entitled to return it on the basis that it now isn't durable and it's now damaged, because it was sold for domestic use. It was not sold for commercial use. And in such cases, there's no right of return. But where the mattress is stained, consumers now stained the mattress. There's no doubt that when it went to them, it was clean. They've spilled something on it, dogs urinated on it, who knows, mattress is now stained. But regardless of the stain, the damage defect would have provided a right of return. The wooden frame cracks. The leg collapses. There's some structural damage to the product, irrespective of the stain. The stain had no influence at all on what is actually the problem. Then they can still return it for a refund or replacement. You cannot turn around to them and say, we don't take it back because there's a stain on the cushion on top, when it's the wooden frame which has a defect because it wasn't properly made or the wood has collapsed. Another thing that's very important, where a consumer has a right of return, no deduction is permitted for the use period. You can't say to the consumer, you've had this now for 3 months, we're going to take 30% of the price for usage. Not allowed. If it's a failure and the product is liable to be returned under Section 56, you must either replace it or refund the full amount which is due. What about product liability? Now we're getting more serious. Now, if somebody gets harmed or injured or something like that, so producers, importers, distributors, and retailers are collectively and individually liable for any harm, including economic loss, if you supply unsafe goods. You know, the stain might be a chemical stain. It might be a sign that there's glue or something on the inside which is starting to come through. In the case that I dealt with the carpet, that was in fact the case. The incorrect bonding agent had been applied, which kept coming through the carpet. A product failure, defect, or hazard in any goods. I'm sleeping on the bed, all of a sudden one of the legs collapses and I fall off, or I have a heart attack or something. And then finally, inadequate instructions or warnings of hazards that may result from the use of the goods. Now, this is interesting, because there's nothing wrong with the product. Objectively, the product is perfect, but it lacks instructions or warnings of what can happen when the product is used or if it's not used correctly. Thus, clear instructions, warnings on how to protect the mattress, for example, against stains and damage, and how to ensure safety when sleeping on the mattress are critical. If the mattress is made of a flammable material, it shouldn't be, I'm sure there are standards for this, then one would have to have a warning, don't smoke in bed, or don't have a heater near it, or, things like that. So that's what I'm talking about. There's nothing wrong with it, but you need to have the proper instructions. Sorry. The defenses for the supplier are that the defect was not present in a product when it was sold by that party. For example, there was no stain when it left the shop. There was nothing wrong with it. Maybe the consumer picked it up in their own bucket and then it fell off the bucket and they broke a leg. Well, they can't then come back and say, well, it's got a broken leg, because actually there was nothing wrong with the product when they picked it up. The damage was caused after it left your control. If the defect is caused solely due to a supplier complying with instructions from the person who supplied it, so they are a retailer and the supplier tells them, you can stack these 10 high, but when you put the 7th one on, it falls through. Then that would be a manufacturer instructions that are wrong, and the retailer would not be liable. Interesting one is D. It is unreasonable for the distributor of retailer to have discovered a hazard having regard to their role in marketing the goods to consumers. But you also can't claim complete ignorance, because if your business is selling mattresses, you can't say, well, I know nothing about mattresses. If the mattress doesn't smell right, or you can see there's a stain, or the person in front of you is a big guy and he's trying to buy a small bed, you can't later say, well, we didn't know. And then, of course, the last ground for defense is that the consumer has just waited too long before bringing their claim. Almost finished now. So let's talk about fraud by consumers. Up to now, we've been speaking about consumer rights, but there's another side to this coin. And this is a consumer. He's had his mattress now for 5 months, and he decides, you know what, I feel like a new bed. So he creates a situation where he can then give you the bed back and get a new one. And in South Africa, unfortunately, there's no protection for business in the Consumer Protection Act. In other countries, there are criminal sanctions in their consumer laws to discourage abuse of these laws. So in America, let's say in the state of New York, if you try to defraud a company by invoking their consumer laws, it's considered fraud and you can go to jail. So in South Africa, it's not in our consumer law, but our common law still exists. And if you're a retailer or a manufacturer, and clearly in front of you is somebody trying to defraud you by claiming that a product is defective, meanwhile they have damaged it intentionally in order to be able to bring it back for a refund, you could go and lay a charge at the police station and have that person prosecuted. So, to sum up, what is the right of return of a stained mattress? Where a product would be eligible to be returned for a repair of a refund, if it's been altered in any way, if the damage is a result of not following clear instructions provided with the product, or there's been product abuse, for example, sold for domestic use but used in a play school, or interestingly enough, I saw mattresses in a dog hotel. Those of you who can believe that there are places like a dog hotel. Then person couldn't return it and say, but this mattress is now defective because they've actually abused the product. But where the mattress is stained, but regardless of the stain, they would have been able to return the product. In other words, the damage or the defect is unrelated to the stain, then they are still entitled to return it for a refund or a replacement, and you cannot make any deduction for the stain, and you cannot make any deduction for the period during which they used it. That's it. Thank you very much.
Thank you, Janos.
Thank you
for such an insightful presentation. And ladies and gentlemen, now we are going to allow questions. And to remind us, we still have Janos on the platform and as our expert, and Mahauta, our ombudsman, and Nikki, our complaints manager, to assist in providing guidance to some of your questions. And now I'm going to allow your digital hands to be raised so that everyone gets a chance to raise their questions. And those who like to still post on the chat box, you are allowed to do so. Thank you so much. I will allow that if I identify your digital hand, you can then unmute yourself and raise the hand. The first person that I see the hand is Tumisang. Tumisang, the platform is yours. You can unmute yourself.
Good morning, colleagues. Mine is just referring to subsection 2 of section 56, where it says, after 6 months, at the supplier's expense and risk. Now, I would like to know, especially in our rural areas. I hope I'm clear, colleagues.
Yes,
We
you are
can hear
clear,
you.
Tumisang.
Okay. Now, where you find some furniture shops, particularly in the furniture shops, there is no transport available. Now, you as a consumer, because you need this product, you undertake delivery upon yourself or with the assistance of a third party there. You have inspected the product at the shop, you take delivery with the assistance of a third party. Now, should anything happen to the product, once you get home, can the supplier say, but you had been negligent along the way? I just want clarity as to, in terms of the supplier's risk. Does he take the full responsibility, undertake the risk from the moment it leaves the shop up until it reaches home, irrespective of who undertook delivery of the products? And then number 2, is that we also have a challenge when we meet consumers. You'd find a situation where a complaint has been laid at the shop to say we need to return the product. Now, the challenge here becomes the delay in terms of the supplier undertaking the expenses to deliver the product back to the shop so that remedy could be given to the consumer. So clarify on the risk as well as the expense where there's a delay on the part of the supplier. Thank you so much.
Shall I answer first?
Yes, you can go
Janus,
ahead.
thank you.
Okay. So the first question is, the first part is, when the consumer organizes their own third-party transport, then the minute it leaves the shop, it's their risk. But if you are organizing as the retailer third-party transport, which by the way happens more and more as companies try to outsource things, they can't shirk the responsibility. If you as the retailer are the one that's charging the consumer for the transport, but then organizing third-party transport, then you are responsible for the transport. If you tell the consumer we don't deliver, here's a list on the wall of 5 guys that can do it for you, contact them yourself, pay them yourself. Then from the time it leaves your door, it becomes the consumer's problem. That doesn't change the fact that the consumer could still try to say, well, the product was defective. It must have been like that when it left the shop. And that's why it's very important at the point where the consumer takes it over, someone from the retailer must stand with the consumer and you do a checklist and you sign it off. There's nothing wrong with the product, and then they put it on the bucket. So that removes that risk. The second question was the one of time. So when the consumers lodge their complaint, in terms of the CGSO code, if I remember correctly, Mahata will correct me, I think there's 15 days to deal with the complaint before it can be escalated to the CGSO. So there is obviously a time allowed, but the retailer can't wash their hands. They can't simply say, oh, well, it's a supplier's problem. You know, if you took the consumer's money, you must deal with the problem. The consumer didn't buy it from your supplier, and the consumer actually 99% of the time doesn't know who your supplier is. So as a retailer, in terms of the Consumer Protection Act, you have primary responsibility because you are the one facing the consumer. So it's not good enough to say, well, the supplier just didn't come back to us. If the supplier didn't come back to you, then unfortunately, retailer, you will have to bite the bullet and pay back the consumer and then fight with your supplier later. That's my view.
Thank you, Janus. I just want to say with the issue of deliveries, consumer taking deliveries by themselves, we have a huge problem in relation to television sets, where the consumer decides to take delivery of the television. It was inspected in store, it was perfect. It gets home and it has a crack. The consumer doesn't have a claim, unfortunately. So we always warn consumers never ever to take delivery of themselves of things like and install television sets themselves, especially these very large televisions. So that's just a warning if there's any consumer here. Thank you.
Thank you, Mahauta. Indeed, that's true. I'm recognizing Nomhle there and Mike. Nomhle, I'm handing over to you, then following will be Mike. Thank you.
Okay. Thank you, Omar, and thank you for the really useful and informative discussion. Really appreciate it. So my question to Janusz is just in terms of Section 61. I wanted to know if that strict liability applies to all consumers, including juristic entities, and if not, is there like a monetary threshold, i.e. certain juristic entity consumers that it would not apply to, and what is that monetary threshold? Thank you.
Thank you very much. Good to see you again. So the Consumer Protection Act considers any business with a turnover of less than 2 million rand a year or a net asset value of less than 2 million rand a year to be a consumer. So therefore, it would apply in those circumstances as well. Typically, that would be a very small business, spaza, a little taste neighborhood type setup, maybe a guest house. They have a fairly small turnover. The guest house one gets trickier because although they have a small turnover, their net asset value could be way over 2 million if they own the house. And then they would fall outside that requirement. Truthfully, it's a difficult one because when they wrote the act, they never defined what is net asset value, what is annual turnover. And I'm not an accountant, but actually I've discussed this with an accountant, and he says there are different ways of calculating this. And depending on who you are, you can make it look like more or you can make it look like less. So if a person is really small and they've got a 50,000 turnover, then it's easy. But if they are close to the 2 million, it can be very tricky whether the Consumer Protection Act applies or not.
Okay, so thank you, Jan. So just to rationalize it, so anyone who is over the 2 million rand turnover or that threshold, then the Consumer Protect, that section would not apply to them, i.e. you would negotiate the terms of the liability. Is that what we're saying?
But must be clear. But that's liability. So it gets tricky because obviously if there's a business, there may be a consumer at the end of it.
Yes.
So I'm staying in the guest house. The guest house can't rely on the Consumer Protection Act, but their guest can
rely on.
So, and then the guest might have a claim against the supplier because they got food poisoning or burnt themselves or something. So,
Understood.
Although I say it doesn't apply directly between those two, but it does apply to someone else in the supply chain. Yes, yes.
100%, 100%. Thank you so much. Thanks, Janusz.
Yeah, on mute, Omar.
Oh, thank you, Mahauta. Thank you. I'm handing over the microphone to Mike now, and then I'll go to Andrew. I'm also acknowledging the chat box. I will address it after Andrew. Thank you so much. Mike, over to you.
Hello, everybody. Thank you. Very informative presentation. I just have a question regarding one of the earlier slides where you mentioned about the minor repair that can happen to a product. Did I misunderstand that part in terms of what you can repair, in terms of what is considered a minor repair? So for argument's sake, if we had a product that you had to just tighten a screw and then the product works 100%, would that be considered a minor repair, and would it be considered an out-of-box failure and we have to credit?
So that is, of course, a very interesting question, and it is, of course, a judgment call. You know, there's no rule you can look to. But what has happened, if you look at MIOSA and you look at the rulings by the National Consumer Tribunal, mainly in relating to motor vehicles, because apparently this comes up a lot with motor vehicles, is that whether the defect is not what they term material, it doesn't affect the usability, the purpose for which it's purchased, and it can be fixed easily, then in fact the consumer must accept a repair. Now, that's not entirely how the Consumer Protection Act is written, but that's how the National Consumer Tribunal has been interpreting it. And I think it's correct. You know, if it's just a matter of tightening a screw, touching up the paint somewhere, I think it doesn't detract from the usability for the fitness for purpose. In the case of our mattress, of course, a stain on a mattress can have one of many causes. And clearly a consumer can't be forced to accept a mattress which has a blood stain on it, or you know, human waste or something like that. Even though it might be cleanable.
Okay, but, and in this case, if the tightening of the screw or the loose screw is causing an operational issue, then certainly it would be considered a out-of-box failure.
No, not necessarily, because if my vehicle is not, I'm trying to use an example of a vehicle. It's very difficult to think of an example with a mattress, but let's think of a vehicle. So I have a problem with the gearbox. You know, the National Consumer Tribunal has ruled that it's fine to fix the gearbox. So the loose screw may be causing an operational problem, but as long as once I've tightened the screw, it is now good to go and fit for purpose, then it's fine. But remember the provision that if a problem arises a second time within 3 months, then you're in for the refund. So the first time you get the opportunity to fix it in many cases, but thereafter that option is gone. Then the only option left is refund.
Sorry, even if it is a different cause for the fault?
Well, the Consumer Protection Act, so the Consumer Protection Act doesn't say if it's the same or different. What it says is, and I'll quickly zip down so I don't get misquoted, it says, the 3 months here, if a supplier, sorry, so just check, yeah. If a supplier repairs any particular goods or any component of such goods, and within 3 months after that repair, the failure, defect, or unsafe feature has not been remedied, or a further failure, defect, or unsafe feature is discovered, the supplier must replace the goods or refund the consumer the price paid by the consumer for the goods. So the option to repair falls away after you've had one go. So it's not necessarily the same thing, because it specifically says here, or a further failure, defect, or unsafe feature is discovered.
Okay, great.
That's 56.3.
Thank you very much.
Pleasure.
Thank you, Mike. Thank you, Janus. Andrew, you are welcome to take the platform.
Thank you. Thank you so much, everyone. Just got 2 questions. Firstly, if an online retailer advertises a price and you make the purchase, they send you the invoice and they confirm delivery will take place in 10 working days, and they come back after 2-3 days and notify you the price was wrong, they're going to cancel your order. Can you still fight that in a way that they need to honor the price because they sent to the pay invoice already? And my second question is, if you buy something under warranty or guarantee, say now the guarantee is 12 months and you send it back for repairs after 6 months, do you get an extended warranty on top of that, or does your guarantee period stay on the initial 12 months?
Okay, let me start with the second one because it's easier. So the Consumer Protection Act makes it very clear that there's a 6-month period and a further 3-month period. It doesn't start again. So if within this first 6 months you return the product and they do a repair, you get a second 3-month period if something goes wrong. If you have a 1-year warranty, the first 6 months of your 1-year warranty are the CPA warranty. The second 6 months are whatever their terms and conditions are. It's a voluntary freebie warranty to you. They're under no obligation to give you that warranty, so they can have whatever terms they want within limits in that warranty. So no, it doesn't start again. Let's go back to the first question, because that's very interesting. So I actually had to get an opinion on this from the National Consumer Commission, because it was very interesting. You know, a couple of years ago, around Black Friday, there was a debacle where things were being advertised and then they couldn't supply them, then they couldn't, eventually they cancelled and they wanted to refund the people. And the National Consumer Commission gave a non-binding opinion, you know, their opinions are non-binding, that as long as the terms and conditions on the website state that until the product is dispatched, they have the right to cancel, they were entitled to cancel if the reason was that they didn't have stock. So what they can't be doing is deciding, but we can sell it for more and then sell it for more. But what they can do is if they sold out, they've taken your order, taken your money, but now they can't supply you, then they refund you. I don't know if, I know Magauta mentioned this as one of the issues that she had been dealing with. Maybe she has a different view on this.
Yes, we do receive quite a lot of complaints with online shopping where the consumer, I'll give an example, a 70s, I don't know if there's a 70 centimeter television in this world. Let's say the biggest one is 30,000 Rand. And by mistake, they put out a price that says 3,000 Rand. And these things are automated. So the transaction goes through, confirmed, because of course, at that time, the pricing is what it is. And maybe a few minutes later, they realize that the price should have been 30,000 instead of 3,000 Rand. Obviously, the Consumer Protection Act says the price you see is the price you say you pay, unless a reasonable consumer could recognizes that there is definitely a mistake. So you can't expect to buy such a big television for that is usually costs 30,000 Rand for 3,000 Rand, especially when there's no special or anything, you know, it just says it's what it is. So there are circumstances under which they can cancel the order. The SCPA requires them to inform the consumers who were exposed to the price that there was a mistake, and they must amend the price on the website. So we do look at the circumstances under which that happened, and the CPA is very clear. Sometimes a reasonable consumer can see, and we do get consumers who said, I did see that it's possibly a mistake, but they still want it at that price. And of course, we do warn online suppliers against bait marketing, because we do have those as well who would advertise goods at very highly discounted prices, but the stock is never available, which would then be considered bait marketing. So yes, in some circumstances, they would be allowed to cancel the order if the pricing mistake was a very clear and obvious mistake that happened. Thank you.
Thank you, Magauta. Actually, I forgot about that angle. I was thinking of a different one because I dealt with a different problem not that long ago, but you're absolutely correct there.
Thank you.
Thank you. I'm recognizing Cindy now. Cindy, you may take the platform.
Thank you, Omar. I am Cindy from Home of Living Brands. My question is, we are a supplier and we also do sell spares to our customers. We do have a service department that repairs the out of warranty goods together with the in warranty goods. So regarding space that we are selling, that we do not have the warranty on the space. And this was, the decision was taken from the previous experiences that we had, where the customers will buy the space and go try repair units themselves and bring back the old space and pretend as if it's new space. Then for that, we said we don't have warranties on any space. But however, our tax invoice that we do give to the customers does say no goods will be accepted for returns. So my question is this under the Consumer Protection Act allowed? Thank you.
Thanks. So the short answer is no. There's no provision in the Consumer Protection Act for saying we do not accept returns. I mean, you can't have a blanket rule like that. In terms of warranty on repaired goods and so on, whether in or out of warranty, it says a service provider, Section 57, a service provider warrants every new or reconditioned part installed during any repair or maintenance work, and the labor required to install it for a period of 3 months after the date of installation, or such longer period as the supplier may specify in writing. So if you are doing out of warranty repairs and charging for them, you have to warrant parts and labor for at least 3 months. And then it says that this type of warranty is concurrent with any other warranty that they have. So, but very importantly, it doesn't apply to ordinary wear and tear, having regard to the circumstances in which the goods are intended to ordinarily be used. So consumer, and then the second grounds when it's not, this warranty doesn't apply, is it's void if the consumer has subjected the part or the goods or property in which it was installed to misuse or abuse. Now, again, this is not a simple thing to determine, because if a person misused or abused, let's say, a power tool, now they bring it back to you. You don't know how they misused it or abused it. But the Consumer Protection Act does require you to give the warranty, and then it will be up to you to show that the goods were misused or abused. You know, there's bits of concrete on the drill, and you can clearly see it was used in a construction site. And the guy brings it back and is wearing a builder's helmet. Then you can say, no, hang on a second. This was used in a building environment. This is a domestic tool. Look at the box. It says domestic tool. But apart from that, there's no provision for a general exclusion of any sorts of goods from the provisions of the law. As I said, except for the situation where goods are given to someone in a specific condition, and they are told it is defective, therefore we are giving it to you at a cheaper price. They accept it as defective at the cheaper price, then they do not have a warranty.
Cindy, are you fine?
So.
Sorry, Cindy, you need to change your practice. It's illegal. That's the best way I can put it.
Yes, it's true.
Maybe consult your news to have. I mean, if somebody brings up a part that is clearly not the one that you sold to them, you can't accept that return. But like Yanu said, you can never have terms and conditions that say there are no warranties, because like Yanu has explained, the CPA gives an automatic warranty for new goods 6 months, for repaired good and other goods 3 months after they have been installed. So maybe consult Yanu and fix that, because before we come and arrest you.
Precisely, Mathauda. Cindy knows this better. She knows. Okay.
Thank you.
You're welcome, Cindy. I'm just going to run to the chat box now before I take Masha. I think I saw your hand.
To say something?
Am I still audible?
Yes, Nikki wants to say something.
Okay, Nikki, that's fine. You can take over the platform.
I just actually wanted to ask on the conversation of repaired goods and warranties, if I've got a fridge and the fridge is 5 years old or whatever, but it
Not good,
needs to
Nikki.
be installed by somebody else into my fridge. Sorry, what's that?
Your network, you are breaking, not very audible.
I think maybe there's a, can you hear me now?
Yes, let's try, Nikki.
Okay,
Maybe switch off your camera.
There we go. That compressor carries a 6-month warranty. Am I correct? Even though it's a part of a grater, but it is still the compressor itself is a new item that has a 6-month warranty. It doesn't have a 3-month warranty because it's a component or a part. Is that right?
Sorry, I couldn't find my microphone switch. You know, it's an interesting point. I don't think so, because it says that if you went and bought the compressor yourself, you went to the supplier and you bought the compressor would have a 6-month warranty. But if you take your fridge to a repair place and they must repair it, then section 57(1) is quite clear. It says a service provider warrants every new or reconditioned part installed during any repair and the labor required to install it for a period of 3 months. So when you give it to someone to repair, then the whole repair, including the labor, is covered for 3 months. If you go and buy the compressor, then the compressor has a 6-month warranty, but then you need to install it yourself. It seems strange. I agree with you. I haven't thought of it that way before. It is strange, but that's how it's written.
It's a true. So now, say I go and buy a new compressor and I get my electrical guy, whoever, to fit it, and then the fridge conks out after 2 months, and it is the compressor. Now I want to take it back to whichever supplier I bought it from. They're going to potentially be able to turn around and say, but your guy installed it. So now I suppose maybe I'm going into a whole off the topic conversation here, because now is it the compressor? Yeah, so it would still have a 6-month warranty, but was it installed properly? But I suppose it's probably a whole nother topic.
Yeah, no. Obviously, if the supplier then sent the, because remember, they don't have to give you. It's not an ATM. They don't have to say, okay, give me the compressor. Here's the cash. They can say, look, we need to look into it. And if they open it up and they see, but hang on, this was wired incorrectly. You can see that earth and neutral was swapped because it's melted the coil. Then they would say, sorry, it's an installation problem. We're not refunding you.
Okay, thank you.
Thank you.
Yeah, and that's right. In those instances, I mean, we've seen a lot of complaints in that regard. So my advice to consumers is get if it's a certain brand of fridge, rather pay a little bit more and get the brand owner to install it. Then you have a leg to stand on, because what happens in the complaints that we've seen, people go to somebody in the corner there who promises that they know what they're doing and they know the brand, and then they mess it up. And then the person who sold you the compressor then says, no, the product was completely fine. It was definitely the installation. It was installed incorrectly, or it was messed up during the installation process. Thank you.
Thank you, Osmahauta. Are you fine, Nikki? Happiness. Can we proceed? Okay, before I take
happiness, yes, thank you.
Okay, before I take Masha, let me go to chat box. There's a question here, Janus. Patrick, what is the period within which to bring the claim for defective goods under section 61?
Oh, under section 61, it's for harm caused. It's not the fact that it's the goods are defective and you want to swap them. So section 61 actually doesn't have a time limitation. You know, that's why people do product recalls sometimes years later. I heard the most amazing thing yesterday, that one of the tire companies in America is doing a recall on tires which it sold 17 years ago because there were 95 accidents due to bursting tires. So there's no specific time limitation if something is dangerous because of its inherently, there's something wrong with its design, there's something wrong with its manufacture. But in terms of returning goods because they're defective to get a refund, you've got 6 months. And I hate to say this, 6 months and 1 day is too late. You know, I've been to the National Consumer Tribunal to help a consumer with a claim, and it was during COVID, and they couldn't go, and they had all these excuses. And the NCT says, regrettably, you have 6 months. That's a law. If you didn't raise your complaint within 6 months, you didn't raise your complaint.
Thank you for bringing that out, Janus. Very vital information there. I'm going to allow Masha Govender, please take over the platform.
Thanks, Oma. This is actually a follow-up to Cindy's question and Nikki's question. With regards to sale of repair parts. So in other words, as a manufacturer, if you sell spare parts directly to the consumer, but these are electronic or electrical components, and consumers who don't have the necessary skill sets, etc., try to repair the unit, and then the component fails and they bring it back, not necessarily the compressor or something where you can clearly see, but an electronic or electrical component. Can we reject that return on the basis of we're not sure how it was installed? Because you're unable to determine, because they'll bring back just the component. So you're unable to determine how it was installed.
So, you know, that's a very tricky one. And I think the presumption in terms of the Consumer Protection Act actually favors the consumer. So when in doubt, it's in favor of the consumer. You can't simply say, we think because you can't prove to us how you installed it, you must have installed it wrong. You can't do that. You will have to have some sort of protocol in terms of which you can determine that it was in fact incorrectly installed. And Section 56(1)(a) says that you're covered by this warranty, except to the extent that those goods have been altered contrary to the instructions. So somebody's gone along and they've cut off a little part so it can fit easier, or they've altered it in some way, or that they have in some other way gone and abused the, I'm just trying to find the exact wording here. Sorry, just expressly informed. That's not it. Yeah, okay, yeah. So a warranty is void if the consumer has subjected the parts or the goods or property to misuse or abuse, and it does not apply to ordinary wear and tear having regard to the circumstances which the goods are intended to ordinarily be used. So where a part is so specialized that it requires specialized installation, and obviously you've got to be careful, don't make it up, because the Competition Commission will come after you. So this is really important. Whoever's making this decision must be damn sure. This is not a user exchangeable part. We are not going to sell it to you. But that doesn't mean you don't sell it to another installer that's not part of your company, who is in fact a professional installer. I'm sort of mixing competition law now with consumer law, but we need to be clear on this, because you can get into a lot of trouble by saying, we don't sell parts to anyone, it's too difficult, we're the only ones that know how to do it. And then other companies come along and say, this is nonsense, we can do this every day of the week. Maybe the general consumer can't do it. So those are the considerations you have to have. And if there are parts that are really problematic and have to be installed by a specialist, then you are entitled to say, we do not sell these to the consumer directly.
Thanks,
Yes.
Sorry. Definitely assists us, because then we can limit sales to the direct consumer, but not to other installers. And that would provide a little bit more structure for us, especially with electrical and electronic components. So thank you.
And you know, it actually came up in Europe and everywhere, for example, with watch repairs. This is a very interesting one. There was a complaint, I think, against the company that owns Rolex and a few other watch companies, that they stopped supplying parts and said, no, only our authorized repairers can work on our watches. And this was taken up to the competition authorities, and they came back and said, no, repair of these watches is a highly specialized task which requires specialized training. And therefore, they are entitled to only supply the parts to those people that have met their minimum requirements.
Yeah, thank you, Janus. And in practically, when we deal with complaints where the supplier claims that the consumer abused the product or misused it, we usually require a technical report that proves. So it cannot just be the supplier saying that without any proof. And if they are not able to do so, we sometimes appoint our own expert technical people to go and do an assessment of the product. Thank you. So what I'm saying, you can't just claim it. There has to be proof.
Thank you. Thank you so much to Masha's question and to the comments given by my panel there. I'm going to go to the chat box. I'm going to read Mr. Ibrahim as comment there. He says he also found that the consumers must be advised no stain removers or any other chemicals product to be used. How can it then be proven within the period of 6 months? I think he's saying, how can we then prove, or they prove as suppliers, that the consumer has used stain removers or chemicals? He then has a follow-up comment to say, if it's within 6 months, he's then concerned about the unsanitary condition, health risk to anyone. This cannot be acceptable. And I'm also going to tie it up with Mantombi's question. She's saying, what happens if the supplier rejects a mattress based on hygiene reasons, as there is a stain, but the main defect was spring? Can we enforce the supplier to replace or refund?
Thank you. So as I said in my presentation, you can't rely on an unrelated issue to refuse a claim. If the springs failed or the wooden frame collapsed, then the fact that there's a stain on the cushion is entirely irrelevant. And they must take it back and repair, replace, or refund as the CPA requires. The only time that a user or a consumer created problem becomes relevant is if that problem then results in the failure of the product. As I say, a person goes and modifies it in some way and then it collapses. And it's collapsed because they modified it. But a stain on a spongy cover can have no impact on the fact that the springs failed or the frame collapsed. So that question is easy to answer. Those are unrelated issues. The one of hygiene is also actually a red herring, because if I'm returning my bed because the frame collapsed, of course it's unhygienic. The bed's been in my house for 6 months. So of course I'm allowed to return it, because you're not going to be able to do with it anything anyway. You must take it and destroy it or whatever it is and refund me. It's not a matter of, well, now it's unhygienic, because of course it's unhygienic. In terms of the question of how will you know what the consumer sprayed it with and so on, again, this only arises if the spraying with the chemical caused the stain. I mean, if I sprayed the bed with, I bought one of these stain guard sprays. I don't want to use any brand names. I went to the supermarket and I bought 4 aerosol cans, and I came home and I sprayed the bed. The box frame collapses later. That's got nothing to do with the fact that I sprayed the bed. But if I sprayed the bed and there was an instruction that said, do not spray anything onto it, and actually the reason is very simple. The materials used to make the quilted top react with the spray and cause stains to appear? Well, as a manufacturer of the bed, you should know how to identify that. Because at the end of the day, you've put the warning on, so you must know that there's a problem. And accordingly, you would need to be able to show to the Ombud or to the NCC or whoever that these stains result from being sprayed with a chemical substance. And if necessary, you would need to take a piece and send it to the SABS or some other lab and have it tested. But those are the short answers to the questions.
Thank you, Janus. Thank you for that. I see Ibrahim is not so happy, but I'll go back to him later. I'm acknowledging Bonani. Bonani, are you still there?
Yes, thank you. Can you hear me?
Yes, we can, Bonani. You can go ahead. Thank you.
Okay, I'm Bonani Dube from Mpumalanga Consumer Affairs. We have a case that we just recently received, but it's a motor vehicle case. A consumer saw an advert on another website of a car that says this car is a 2020 model. It's got 11,000 kilometers. Went on to make electronic payments. I think they say they sent someone in Gauteng to just go check. The consumer is based in Mpumalanga. So they brought the car, someone brought the car for delivery. And then ideally the consumer had bought the car with the intention of also reselling it to this company we buy cars. So now, upon arrival, they realize that the car does have those 11,000 kilos, but the body has been repainted and the windscreen refitted and lots of body issues. They actually took it to those experts and then they evaluated it where the consumer wanted to resell the car. They say the body is full of refills and all those things. It doesn't even merit the price that the consumer bought it for. So now the consumer wants to return the car back and the seller says, no, you cannot bring it back. I think on the invoice, it was written also, you can't bring it back like sells wood stools. The car is sold as it is in the invoice. So I just wanted to check how do you deal with that one?
Okay, so very interesting. Of course, Voetstoots only applies to auctions. There is no business that can sell you something Voetstoots. I'm presuming he bought it from a garage and he didn't buy it from a private individual. But I actually had a very similar case during lockdown where I helped a consumer for pro bono, and we took the matter to the National Consumer Tribunal, where the consumer bought a vehicle from another province and it was delivered with a truck. And when the vehicle arrived, it was not at all like it was shown in the photograph, which he had been shown when he purchased the vehicle. The body had dents, there were various problems with it. And where the consumer was successful was because from day one, he never accepted the vehicle. So what a lot of consumers, the mistake they make is they'll take the vehicle, start driving it, and start complaining but driving. And then the National Consumer Tribunal says, but look, it's fit for the purpose for which you bought it because you were driving it. Surely the purpose of a vehicle is to drive it. But if on the day one, you point out what all the problems are and you refuse to take delivery, unless you're being completely unreasonable, you're probably entitled to a refund. And the National Consumer Tribunal would probably rule in favor of the consumer because they had been misled as to what is wrong with the car. And from what you've described, it's highly unlikely it can be fixed because you can't return the clock back. If the car physically is not what it's supposed to be, the body has been changed, the windscreen has been changed, they can't change that back. we've also got to be careful, though, how was it advertised? So the wording of the advertising is very important. What is it that was on offer? Did the consumer presume something while meanwhile it was never said? Remember, the car was being sold at a very good price. So the consumer thought he was grabbing a bargain, but he wasn't getting a bargain. So you would need to go and look at how was it marketed, how was it advertised, are there WhatsApps, SMSs, emails, what was the discussion? And then one can determine, was the consumer misled? That would be in terms of section 29 and section 41 of the CPA, and therefore, should they be entitled to return the vehicle for a refund, but then they mustn't be using it.
Thank you, Janus. Okay. And of course, the Motor Industry Ombudsman deals with such complaints. That would be the next port of call because the consumer is not in Mpumalanga. Thank you.
Thank you. Thank you so much. Janus, when you were addressing the issue of stains and health risk, then I saw Ms. Prudence Muilwa then said, please reference section 23 to the argument.
Let me have a look, section 23.
Maybe she can help us and talk to us about it. It's better if it comes from the person who's raising the issue. Prudence, yes. Thank you.
Thank you. I apologize. I joined the discussion a little bit late. I was just, because section 20 subsection 3 makes reference to the goods that cannot be returned for reasons of public health and so on. And I think also in your argument, you did make reference to issues that are affixed. And I think section 20, subsection 3 makes reference to that. So I wanted you to maybe just reference to it, subsection 20, subsection 3, because it deals with the return of goods, where consumers can return goods for a full refund. And I think it deals with the permutations. The entire section 20, I think, deals with the different permutations under which consumers are allowed to return goods. And exceptions to that kind of rule. Thank you.
Yeah, thank you, Prudence. Subsection 23 speaks to public regulation, so no one can just decide that this is a public health issue. It says for reason of public health or otherwise, a public regulation prohibits the return of those goods to a supplier. So it is if there is a law that says you can, and we know that
at the moment, the only law is medicine, so you can't return medicine. There isn't another one at this stage.
Yeah, and we know that there are also some acceptable ones like earrings and underwear, but generally a supplier cannot just decide on their own that it has to be a regulated substance through regulation that says it cannot be returned. So a mattress stained would not fall within section 23.
Thank you, Makhaut and Janus, for clarity on that one. Do I have a hand that I'm missing? I think we have covered all the comments and questions on the chat box. Generally, we are receiving comments that says that this is a very well informed webinar. Thank you very much for that. And okay, yeah, I was just trying to catch what is on the chat box. I think we are closer to concluding. If I don't see any hand, I'm going to allow the platform to Makhauta to give the final remarks. And yeah, but from my side, thank you so much, everyone, for staying with us, for joining the webinar. I'm handing over to Makhauta for final remarks. Thank you.
I think Janus should give some final remarks as well in terms of his advice. But yeah, thank you very much to everyone who attended. Law is not a straightforward thing. I mean, you always have to look at the evidence in front of you. You have to look at the circumstances. You have to look at all the permutations that are in the CPA. But at the end of the day, there are some basic rules that we all need to understand and comply with regards to warranties. Basic one is that there is a 6-month warranty with regards to defective goods. I think the references to section 20 are in relation to goods that are not defective, but other circumstances under which a consumer has the right of return. And I think Janus dealt with those at the beginning. For example, where the goods are not defective, but there is a right of return when there has been direct marketing and they cooled off within a period of 5 days, they cancelled, where they had no opportunity to inspect the goods, where the goods were not fit for purpose, that was properly communicated to the supplier. Somebody says, I want a computer that can do 1, 2, 3 when they get home, and the supplier says, yes, this computer can do what you want, and it doesn't do that. It's not defective, they have a right of return. So today we were mainly addressing where the goods are defective. Thank you very much. Janus?
Thank you, Makata. And again, thank you for the invitation. And I always find these forums very interesting because people ask questions I could never think of on my own because I see them from a certain perspective. One thing that's important to know about the Consumer Protection Act, it's one of the first laws in South Africa that deals with equity. What is fair? It doesn't only look what are the strict words of the law. And lawyers often make this mistake. They pick up the Consumer Protection Act and they find some words and they say, but look what it says here. But they forget that the context of the Consumer Protection Act is the principle of fairness and equity to the consumer. And I think that's always important to understand when trying to resolve consumer complaints, and especially in these spheres where there's no immediate right or wrong answer. You have to weigh up the circumstances, weigh up the facts, and then come up with a recommendation. Thank you very much.
Thank you, Janus. I think especially in our context as an ombud scheme that mediates disputes, where the strict letter of the law would be looked at would be in the courts and to some extent at the tribunal. But with us, of course, it's applying the law as well as the principles of fairness and equity. Thank you very much.
Thank you. Thank you to my panel. And ladies and gentlemen, thank you so much for staying with us and for being part of this webinar. We shall circulate the presentation to you all. Thank you and have a great and blessed day further.
Thank you, Osoma. Thank you, colleagues. Bye.
Bye.
Thank you.
Bye.